Thank you. So I have a confession to make. I had kind of sent email to this panel suggesting a certain format, and they have rebelled and have enlisted the aid of my wife in siding with them in their rebellion. So I'm just going to leave it to the panelists themselves to govern themselves. They're governed experts.
Wow.
They should be able to do that.
Hi.
So,
I'm Emily. Nice to meet you.
but I would like just to insist that, if each
I'm Nate.
panelist could
Good to meet you.
just take a few seconds, starting with Emily, to introduce themselves so that the audience can know who the world you are.
Great. Hi,
Thanks very
everyone.
much.
My name is Emily Barabas. I'm a policy analyst at the Center for Democracy and Technology. We're a digital rights organization based in Washington, D.C., but I'm here in San Francisco, and I work on our global internet policy and human rights team.
I'm Nate Cardozo. I'm a staff attorney at the Electronic Frontier Foundation, based here in San Francisco, as are all but half of one of our attorneys. I work on the digital civil liberties team. As Mike said earlier, I do not have the pleasure of heading it as he said that I might. That is in fact my boss's job. But I do surveillance policy and impact litigation.
And I'm Dorothy Glancy, and I'm professor of law here at Santa Clara, and I welcome you all to our beautiful campus.
Hi, good afternoon. I'm Blanca Gordo, and I am a social scientist researcher at the International Computer Science Institute, part of the Artificial Intelligence group and the Audio and Multimedia group, more specifically the Teaching Privacy group, and a visiting scholar at the Institute for the Study of Societal Issues at UC Berkeley. And most, relevant to this talk, I just was the principal investigator of an initiative here in California through the Broadband Technology Opportunities Program administered by the National Telecommunications and Information Administration at the U.S. Department of Commerce, an American Recovery Act fund invested here in California through the Foundation for California Community Colleges. So that gave me an opportunity to think more in depth about teaching privacy.
Great. So I think by rebellion, that means that we're going to just go in this order. Is that the main part of the rebellion? Great. So good afternoon, everyone. Thanks so much to ISOC for coordinating this event, and especially Michael for bringing us all here. It's great to see you and to hear the panels this morning. So I work, as I mentioned, on the global internet policy and human rights issues, and so the comments I'm going to share today are kind of with that bent, and I think we each have a slightly different background, so I think we'll all complement each other quite nicely. So, as we all know, tech is growing globally, and so is the influence of Silicon Valley companies. ICTs allow people around the world to access and share information, communicate, and conduct business across borders. The internet empowers people to enjoy human rights, including freedom of expression and freedom of association. A couple of examples that many of you are familiar with are people using Twitter to organize during the Arab Spring, bloggers and dissidents being able to use Tor and other anonymity tools to communicate without fear of reprisal, LGBT youth participating in online support groups without having to disclose their identity from places where they might be persecuted. Many Bay Area tech companies serve customers around the world or aspire to do so as they grow. These companies want to make effective, user-friendly, secure, and trustworthy tools for customers, regardless of where they're located or what kind of passport they're holding. US surveillance policy is fundamentally at odds with this model, as is the surveillance policy of many other countries, as we talked about a little bit in the last panel. In the US, surveillance programs make a distinction between what it calls US persons and non-US persons. So a non-US person is someone who's not a US citizen and is not physically located in the United States. If you're a US person, you enjoy some protections under the law about how and when the government can collect, store, and share information about you. But for non-US persons, the only restriction on surveillance is that a significant purpose of the surveillance is to collect foreign intelligence information. So what does that mean? Well, it's incredibly broad, and it's interpreted broadly. And in practice, it offers very little protection at all. So, as Declan talked about earlier, under Section 702 of the Foreign Intelligence Surveillance Act, the NSA collects communications data, including things like email and chat records and many, many other things, in bulk. This is what many people call the dragnet, both through requests to service providers and also through tapping the internet backbone. There are no limitations on the retention or sharing of communications data with other government agencies, and the vast majority of people whose communications data is collected are not thought to have committed any crime. They're not suspected of any wrongdoing at all. So it's no surprise that the US government policy and many other governments' policies that are similar are eroding international trust in both the US government and also tech companies based in the US. It's directly bad for Silicon Valley for obvious reasons, but it's also prompting bad policy that could cause further harm in other countries. So a number of countries have proposed data localization mandates, requirements that companies store data about their own citizens within the borders of that particular country. This would be very costly for companies to implement, but more fundamentally, it undermines the open, decentralized nature of the internet and threatens access to information and free expression. So from both a business and a human rights perspective, one of the major changes we want to see is real and meaningful limits on international surveillance and an end to bulk collection. Reform of Section 02 is essential for making sure non-US persons can trust US businesses with their transactions, communications, and online social activities. I also want to talk a little bit about device and network security, which are really important in this context as well. Tech companies already face a significant challenge in building secure products and services and managing security threats. Government surveillance programs and policies, whether they're public policies or policies that they implement that are not publicly disclosed, must not exacerbate this problem by weakening internet security. It may be tempting for the US to seek backdoors for products and services to make them wiretap ready for the government. This is the CALIA discussion. But such actions undermine security for products and services and make them easier to exploit by all sorts of actors. Back to the human rights context, if a human rights activist or a whistleblower can't trust the security of internet services, she may choose not to speak out or may face punishment for her communications. Leaked documents indicate also that the US government may have worked within technical standards bodies to undermine security standards. And there's also evidence that a growing number of countries are using targeted malware as a method of gaining access to people's computer data. I think Nate may talk a little bit about this later, but this is developed countries, less developed countries, democratic countries, non-democratic countries. Some of it's for direct cybersecurity or direct surveillance of terrorists, and in some cases, it's targeted phishing attacks against human rights activists, for example. And often it's similar tools that are being used by all of these entities. Silicon Valley has enough of a challenge managing threats from cyber criminals and other nefarious entities, and governments should not exacerbate the problem and raise costs for companies, and also put the security of users at risk. So policy in Washington has a real and substantial impact on tech companies, and companies need to play an active role in Washington in advocating for good policy. There is some discussion happening in Washington around domestic surveillance reform. USA Freedom Act came up recently. There are some proposals on the table that are quite bad. There are some that are better. Right now, we think USA Freedom Act is one of the better proposals. And companies should support initiatives that support the rights of their users. There's far less discussion in Washington about surveillance abroad, and we'd really like to see that be a bigger discussion in Washington, and that's something that companies can play a role in advocating for their users globally. But unfortunately, policy moves really slowly. We see that often in comparison to the speed at which things move in Silicon Valley. It's an enormous contrast. Technical standards bodies, also kind of slow, but less slow. And technological change happens much more quickly. So it's also really important for, in conjunction with policy advocacy, for tech companies to take the initiative in protecting the security of their users. I want to mention just briefly a couple of really great initiatives led by civil society organizations to improve computer security. One is Reset the Net. It's led by an organization called Fight for the Future. and it's a day of action against mass surveillance in which companies and individuals are encouraged to adopt at least one new security practice. So it's a way to kind of get people moving on the issue of security. Another great initiative is called Encrypt All Things. It's organized by an organization called Access. It's a longer-term initiative to get companies to sign on to a series of better security practices. And CDT is signed on to both of those initiatives, and if you have any questions about them or want to connect with those organizations to learn more, I'm happy to talk after this. So I'm looking forward to a robust discussion, and I'm going to pass it on to Nate.
Thanks. So I'm not actually going to talk much about the Ethiopia case, although I'm happy to take questions on that. I'm an American lawyer, and I'm going to focus my comments today on American law and what American intelligence agencies should be doing better than they are. So what Mike asked us to talk about was a governance approach to reduce risk on Silicon Valley businesses. We're here in Silicon Valley. This is the Internet Society. A lot of people in the room and watching are most likely Silicon Valley types. So hopefully this will speak something to you. So we heard Mike start the morning by saying that surveillance is not necessarily bad, and I wholehearted agree with that. There are a myriad of legitimate uses for surveillance. Targeted surveillance based on an actual suspicion of an actual person. However, even doing targeted surveillance in a way that undermines the trust of those you're tasked with protecting is bad. And mass surveillance will always undermine the trust of those you're tasked with protecting and cannot be good. We see this most starkly with the NSA. That's where Ed Snowden worked, so that's where he had documents from, so that's what we see the most of. NSA is an organization which faces two possibly diametrically opposed goals. They are tasked with information assurance. They're tasked with defending American government and private networks from foreign attack. They're also tasked with foreign signals intelligence collection. Those goals might not be two goals that one agency can work toward at the same time. In theory, having both of those roles in a single agency is problematic at best. And in practice, we see that they cannot work together. I think the most stark example that we have ripped from the headlines is the vulnerabilities equities process. I hope some of you know what that is, but if not, I'll try and give you a quick rundown. After Heartbleed, there was a Bloomberg story that said that NSA knew about Heartbleed and had been exploiting it. The White House extraordinarily quickly came out and said, absolutely not, we didn't know about it, we were not exploiting it, and the denial was worded, and it is an actual denial, unlike many of the other denials that we've seen from NSA. So I have no reason to doubt that particular denial. However, the White House also came out and said that sometimes they do sit on vulnerabilities, and that they have something which we'd never heard of before called a vulnerabilities equities process, whereby they judge the value of a particular 0 day that they know of, the intelligence value to them, against the risk that it puts American government and private networks, that it gives to American government and private networks. That's problematic, especially when we see that the equity that's being balanced here is national security versus private security. If we look at, the NSA has the words national security in its name. It should only be doing things where the equity balances in favor of national security. So if NSA is running the vulnerabilities equities process, what does that actually mean? Does that mean they ever report a vulnerability? This is not something that we should, as people in Silicon Valley, should be left guessing at. Let's go back even further. Let's look at the difference in NSA practice in 1976 when it modified the S boxes in DES, and compare to 2004 when it chose a specific ecliptic curve to be included in dual EC DRBG. That is a massive change. That's a sea change in the direction of the organization. And we see that we see that tension continuing. We see the enduring security framework, which some emails between Keith Alexander and Eric Schmidt were FOIA'd and released by Jason Leopold of Al Jazeera America just this week. This is the program whereby NSA comes to Silicon Valley businesses, helps them secure their products and services, close gaps, do forensics in the aftermath of mainly Chinese attacks, and close those networks. At the same time, we see Muscular, right? This is the program which Declan alluded to earlier, where NSA was actively hacking those same networks. Ken Carter told us that NSA, I assume NSA, a three-letter agency in his words, came to him and said, you're an American business, we can't hack you. Hopefully that's the current viewpoint of NSA, but we know that as of a year ago, that was not their thinking. We see Bull Run, which is the program whereby NSA intentionally weakened encryption algorithms. And we compare that to what's known as the Advanced Persistent Threat, or APT. That's an NSA euphemism, I guess, for China. Yeah, I mean, China is very advanced and it's extremely persistent. And apparently it's a threat. So how do we deal with this? How do we deal with one agency that's tasked with two diametrically opposed goals? I think maybe we split the agency and we have one agency tasked with foreign signals intelligence and offensive cyber capabilities, and one agency tasked with information assurance. And so that when Eric Schmidt calls up the leader of the information assurance agency to come to the Google campus or I guess, secure facility somewhere near San Jose Airport, I don't know where that would have been, but I'm sure there are plenty around here, to come help Google out, they will know that that agency will not also at the same time be trying to hack Google. I think that will go a long way towards restoring trust in our three-letter agencies, and I think that's an admirable goal. But also we need some legal and some policy changes as well. We've heard reference to CALIA a bunch of times. This is Communications Assistance for Law Enforcement Access. This is the 1994 law that required telephone companies to be real-time wiretappable. There is no equivalent online. However, even as recently as last month, we heard the White House talk about the possibility of data retention, mandatory data retention in the companies. And we've also heard of tech-neutral solutions being the answer to this problem. How do we get mass surveillance out of the hands of the NSA and essentially put it in the hands of the private companies? Data retention is essentially CALIA 2. In this fast-moving world, there cannot really be a CALIA 2. CALIA specified some what are now extremely antiquated actual technical mechanisms whereby FBI could get real-time wiretaps. That's not going to happen online. But what might happen is data retention. And data retention is really a terrible idea if it's done for other than business purposes, and I can talk about why later. And we need to resist that strongly. And then in terms of policy, we need to know more. We need to know more about the vulnerabilities equities process. We need to know more about Executive Order 12333, which is the executive order that, without any legal process, allows the NSA to collect information outside the United States. Not even FISA court, nothing, no legal process. And supposedly that's how the Muscular program was operated. This is the program, again, that hacked Google and Yahoo data links. And we need to know more about the sort of thing that happened to LavaBit. And this is the order that apparently asked LavaBit to turn over its private SSL keys. We saw some reporting out of the UK just this week and last that the major tech companies in the UK are withdrawing their cooperation from GCHQ, possibly over a request for their private SSL keys. We need to know more about that because we cannot trust our intelligence agencies to help secure our networks when at the same time they're attacking those same networks. That's what I have.
Well, now you scared us. I'm Dorothy Glancy. I'm a law professor here. And I'm among those people that believe that people have privacy rights in public places. I wrote an article about 10 years ago called Privacy on the Open Road. And about 2 years ago, the US Supreme Court agreed with me in deciding United States versus Jones. That was the case where the surveillance had to do with attaching a GPS device to the vehicle of a alleged drug dealer and following him for about a month of time. So I've studied this area of law a long time, and it's sometimes hard to find something really new, but I actually have something to tell you about that is very new. The day before yesterday, the Santa Clara Law faculty chartered a new privacy law program that's the first law school program of its kind in the United States. Starting next fall, the Santa Clara Law School JD candidates are going to have the opportunity to take a concentration in privacy law as part of their JD degree. There'll be sort of formal training programs for law students who are looking toward privacy degrees. Seems to me that that's a big step forward with regard to figuring out what to do about surveillance. Since, as I think we all agree, surveillance is very difficult to understand. It's highly technical, and as soon as you think you understand it, they change it.
Yep.
Especially in this particular century, we've had lots of changes in the surveillance systems. I go back to a system, I think Mike and I were talking to about the same time, when surveillance didn't have a first name. There wasn't a cyber before surveillance, it was just surveillance. And most of it was done in really very, what would now be considered primitive manners, using wiretaps of coaxial cable and occasionally copper wires. I worked for a while on the Watergate investigations. I was the privacy counsel for the Constitutional Rights Subcommittee that was chaired by Senator Sam Ervin. And I did a fair amount of work on some of those investigations. We were very concerned about surveillance at that time, but it was a much more physical sort of surveillance than what we're talking about today. If you think about it, surveillance seems to have been around for a very long time, but maybe not as long as you might think. A lot of the work that I do has to do with enforcing the Fourth Amendment that guarantees us against unreasonable search and seizures, provides for judicial warrants based on probable cause. A lot of the protections that are offered for privacy against surveillance systems comes from the Fourth Amendment. Do any of you recall when the Fourth Amendment was adopted? 1791. Why is that important? Because surveillance had not entered English, the English language, until well after the turn of the 19th century. The Founding Fathers did not address surveillance directly because the word surveillance was not available to them. So our arguments about surveillance, particularly on a constitutional basis, are largely targeted toward doing some extrapolation from what the core values of the Fourth Amendment are. As we've talked about, and I think Nate was just talking about, there are a number of different kinds of surveillance. What's interesting about cyber surveillance is that it can be used either for mass surveillance or for targeted surveillance of a particular individual. And so when we talk about surveillance in general, we need to be maybe a little bit more sort of precise. One of the major issues with regard to the disclosures of the collection of information about the telephone calls of people here in the United States is the metadata issue. We've talked a little bit about that today. Well, that's a major sort of academic legal issue with regard to whether the Smith versus Maryland case decided in the 1970s and authorizing pen registers to take down the telephone numbers that were being called by a particular telephone. Whether the modern equivalent of that is or is not the header information on things such as emails, that's an issue that will eventually find itself decided by the Supreme Court. One of the interesting things from a legal policy standpoint right at the moment is that the end of April, the two cases involving cellular phones were argued before the United States Supreme Court. One of these cases was called Worry, no, not worry like we're worried about it, but Worry with a U, that involved a fairly primitive flip phone. But it was used to get frequently called numbers so that the home of the person who owned the phone could be searched. The other involved a case out of here in California, the Riley case, that involved a smartphone and the extraction of pictures and information that were stored on that smartphone. We may begin to understand a little bit more how the Fourth Amendment applies to modern technologies, including metadata, when we find out how the court is going to decide that case. I've read all the oral arguments. I was in class when it was being argued sort of directly, and it's very hard to tell how that case is going to come out, but I'd be interested in some expert opinion from my colleagues here. It seems to me that there are a couple of pieces of legislation that are very problematic for surveillance control sorts of issues. Those two statutes, and Mike, I think, already talked about one of them, and Nate was talking about it as well, and that is CALEA, the 1994 statute, that basically allows the government to require all businesses that have something like an outside connection that could be used for the transmission of information by individuals to have a back door. And the back door is a switch. Some of the switches that are made in the Valley are those kinds of switches. Some are hardware, some are software. Most of them are these days are software that allow law enforcement agencies to tap into communications carried by the line with the switch and essentially eavesdrop on all of the content of those conversations with, of course, with a warrant before the content is collected. I think I disagree a little bit with Nate because the CALEA statute hasn't been changed yet, but the application of CALEA to broadband was adopted in 2004 and other changes made in 2007. And that has a major sort of impact on all businesses that have anything to do with communications, because it requires them, if they're operating in the United States, to have a back door so that law enforcement could conduct surveillance, most of it targeted surveillance with regard to people using that network. Well, I've had a lot of fun, and some of my colleagues at CDT have had a lot of fun with me, thinking about the application of CALEA to the Internet of Things, that is the IOT that most of us talk about. Theoretically, to the extent that the Internet of Things has various objects, your refrigerator, your toaster, your car, connected to broadband, it will have to be subject to one of those CALEA switches. And so attaching CALEA switches to things such as smoke detectors, thermostats, and a variety of other kinds of technologies may be somewhat more complicated than some of the people are telling us, because those technologies, if they use broadband, will need CALIA switches. And the trouble with CALIA switches is that they're built-in vulnerabilities. They are security risks from the minute that they are installed. And just briefly about another piece of legislation, of legal policy that is worth a lot of concern, is the Electronic Communications Privacy Act enacted in 1986. And I know the people at both of your organizations have had a lot to do with trying to get the Congress to pass some really very not terribly challenging improvements in the Electronic Communications Privacy Act, at least to get it to talk to the kinds of technologies that we're using in the 21st century. That would be a major improvement. Where we are now is that there are large numbers of co-sponsors for the reform legislation that was put together, the digitalrights.org changes. But the legislation is kind of hung up in the Congress, mostly in the House, although there probably are enough votes to pass it. But the problem with getting it passed is, no, not the Federal Trade Commission, not the Federal Communications Commission, not the Justice Department, but rather the Securities and Exchange Commission. Now that has some impact on all of you out there who are thinking about IPOs, because if you have to deal with registration statements for the SEC, or you're subject to SEC jurisdiction, which a lot of fundraising for fundraising for startups is, you're going to be subject to the SEC's practice of, without a warrant, simply engaging in wiretapping, in using the CALIA backdoors and engaging in wiretapping based on the SEC providing administrative orders, essentially giving themselves permission to wiretap people with regard to SEC kinds of situations. So what we have is a really good improvement in terms of legal policy, fixing, at least to some degree, the Electronic Communications Privacy Act, but it's hung up on the fact that the Securities and Exchange Commission is using the ECPA and wants to be able to continue to wiretap without warrants. So that's sort of where the legal policy debate is, sort of an academic perspective on it. And I was thinking about, and I urge you to think about, really what sort of grade should we give legal policy with regard to cyber surveillance? We have a little bit more to talk about, of course, today. Even on this panel, there's a lot more to talk about. But at least from my point of view, I'm leaning toward a pretty low grade for legal policy in confronting cyber surveillance.
Great. Thank you so much. There's so much to talk about. I am an urban planner by training, and we are always thinking about how researching contemporary issues so that we can inform decision making. That's the ideal. And in so doing, I study poverty and economic development, and that's how I got engaged in the idea of privacy. In particular, I was most concerned about the effect of being offline, and then second, what the solution to that problem is. And that's where I confront this question from a mother who asked me, or who said, you know, Dr. Gordo, we give these children birth, we feed them, we clean their butts, and now they're supposed to teach us, how can I guide and protect my children if I myself do not understand the internet, right? And so I have been pressured quite a bit to come up with 2 things that I would, where lies the solution, the 2 things about the many to prepare this population, which is for industry, the bottleneck. Those are the potential consumers, and it turns out to be about 43% of the Latino population in the United States and here in California, and also about 45% of African Americans and 48% of Native Americans. And for those with less than 25,000 per year, about 57%. And with those with less than a high school degree, about 67%, according to the survey that we have from the census. And for 65 years and over, it's about 55%, which is the fastest growing population as well. So here we are with this dilemma that technology matters because it's an institution, right? It's not just a tool, it's a process of production, consumption, and exchange. Always has been. What is new is the integration of new set of information in telecommunications technology, the network, let's call it, of you call it the Internet of Things, of multiple interoperable devices that are meant to be open and communicate with each other. That's why we love it. It's where we exchange and exchange information about ourselves, about products, and communication with public and private institutions. The question is, what is privacy, right? The effect of the Snowden has been that it has brought to the light at a point where you can no longer avoid the public discussion about what is privacy. That's both the opportunity and the challenge, and the answer depends on who you ask and what they know. This is what makes it both interesting for scholarship, but also scary for public policy making, right? It is these laws are now going to enter the Supreme Court, and some of our Supreme Court justices don't use this technology, nor do they understand it. How can they legislate on this? That's the big problem, I think. Therein lies the problem, the lack of a shared baseline of understanding of what privacy is, and that itself is causing disorder at all levels, and you can see it in our conversation. You can see it in any conversation that it's compartmentalized. People talk about children's policy, mobile privacy, children's privacy, as if it could be compartmentalized in reality. It's one system, and it's both social, it's technical, and it's institutional as well. Right? What matters here is the types of policies and the philosophy of the governance that gets to determine how we get to use these set of technologies, and how we might regulate this. And the society also regulates itself at the individual, collective, and family. And there's differences in culture as well that get to tell us how we engage socially, economically, produce, and communicate with institutions and so forth. So the problem is that this lack of baseline and understanding, lack of standard guidelines about what this is really fueling misconceptions and reinforcing the problem. And the misconception is about what's technically possible and what's socially possible as well. That is going to, and this compartmentalization too is keeping us away from the focus of the real conversation, right? I think it's a good opportunity for every player to examine themselves, because we have to come to the table and decide what are the trade-offs and exchanges to function online, and there is ill will. And how do we regulate that? And I think one of the things that our colleagues are talking about is we should know what you're looking at and what you're doing with it. I think that there's a tension precisely because industry did collect everything without thinking information. That was the get-go at the beginning of this collection. Everything's important. That's what big data is, right? Everything is important until you lay it in the social structure of what is, which is unequal as well in terms of protection. So for me, I think one thing that we can do is to be aware, not to reinforce a misconception of what is and correct an error, when there is one. I don't think that, I think the problem too is that both the people who are deciding on this and the users themselves, one thing that we share is that, you know, we're not even talking about the same thing. And there's disorder in the expectations. There's a disconnect as well in the larger social scheme of things between those who have embodied collective systematized knowledge through their socialization and their own experience of being offline. Nobody taught us technology. We started using it. We started learning with it. We started acting with it. And now we're at this place where we have to discuss frankly, what are the trade-offs? Well, how much information is actually needed? For what purpose? For whose benefit? At what point? It is precisely because corporations collect the information that government is asking to see it. Yeah? Because of that. So it's interesting. Last year, there was a lot of contention about whether we should tell the public or not what you're doing with the information, and people were contesting the framework that the White House put out. Tell people what the information is. It was as basic as telling us what they're doing with the information. There was contention. Now there's a focus on the government. Either way, there's disruption in the home between the gap between the young people who know the technical information and the adult choices and beliefs or attitudes about what's private or not. I think what's important and helpful is, or at least the way that I'm tackling this, is to think about the people who can least afford the cost of connectivity and who are most vulnerable. And those are the people who understand the least about how the social technical network works. And we ought to think about, too, the language that we use. It is a network, okay? And the multiple devices in which you connect do matter. Of course, the problem is that this industry isn't regulated, which is part of the barrier behind this public discussion or contention. It's a game, right? It's policy, there's different players, and it's just now happening in the public realm. I think one population that we should be concerned in terms of educating, I think all of us could be educated about it, and actually I want to let you know that we have at the International Computer Science Institute, I came together with my colleague, my computer scientist colleague there, because they were asking him as well, Dr. Friedland, these are teachers, when does what I type get submitted to the internet? When I press OK or before that? You know, how do we explain this to teachers who are in charge of preparing children and new users to get online, right? Because essentially we all have to come to terms with what's a reasonable expectation from what is, not what we think it is. If you look at the Federal Trade Commission, I also examine in the idea of giving people guidelines about, or for me to evaluate, are you reinforcing the problem? Or are you correcting an error? Where are you going when you're introducing this technology to a population for the first time? And when I looked at it, assessed the possibilities from public institutions and other educators, I saw contradictions, right? And this is what I mean about being clear about what we're interacting in and operating with. And that is that one of the guidelines often you hear is, this is how you become more anonymous. Well, I got together with a computer scientist and can we just settle this and come up with some principles so that we understand, so that we ground it from what the discussion is. And there is no anonymity. That is just the reality of the situation. There is no anonymity. Unless it's strongly encrypted, you should assume that there is anything shared over the network is going to be reproducible, possibly, right? Could be used against you. There is no identity that's guaranteed online. When you do share your information over the network, that means that you give control over that communication. You shouldn't have the expectation that a lot of people operate under the idea and they do things where they self-incriminate because they believe it is anonymous. Because they do believe that there is such thing as a Consumer Rights Privacy Act that protects personal and data collection and exchange and selling of information. There is no such thing. So the internet does duplicate, but it never forgets, and our information footprint is larger than we think. And so I think the important thing is to ground this. I am myself very concerned for everyone, of course, but I think in particular for the people who have yet to enter this learning curve. And I think they're also a great opportunity to think about reframing or framing or conceptualizing in a way that helps us come to the table to at least understand that we're all dealing with the same structure and ask what are the rules, and for designers to take a moment and think about their design and whether it's necessary for the function that they desire, and think about the implications of what is being designed, and then design experiential tools. I urge you or encourage you rather, to go to the teachingprivacy.com just to see a sample of what we're doing around that. Around doing those kinds of technologies so that people themselves get to see these set of principles. And I have some flyers for all of you if you want, because we're very interested in getting more feedback. And more important than anything, it's a great opportunity. I am happy that there's discourse, but I do encourage that we ground our discussion in what is, not what we'd like to believe, not fears and not misconceptions. And for that, there's a lot of work to be done. Thank you.
Well, it sounds like we all agree about the need for trust.
Indeed.
Sometimes there's too much trust, sometimes there's too little trust in the internet.
That's at the core of everything. If you don't trust the system, and I found that people censor themselves or they disconnect from the system because they're ill-informed. So there is a cost to it. People do disconnect, but at the same time, it's a cost to society as well, because it is costly not to be online. You don't have an option today. It's part of functioning in today.
Well, and we've seen since the Snowden disclosures that there have been measurable changes in the behavior of people online. There's been a reduction in specific activities such as online banking and a certain amount of online commerce,
right,
because of the generation of lack of trust.
And even worse changes in online. Not to be the negative Nancy, but there was a study, and this was last October, I believe. So only 6 months after Snowden, there was a study released by the PEN American Center of American writers, and 26%, more than a quarter of American writers, had self-censored in one way or another based on the Snowden revelations, only 6 months after. That I think should really dishearten us all, and can bring home the fact that a lack of trust has, and the disconnect that Blanca's talking about, has a real world impact in not just in online banking, but in what makes America a great country, the sort of the free exchange of ideas and arts and sciences and everything, that there is a chilling effect on it all by this lack of trust.
I mean, I think there's a legitimacy crisis, and this is why standards, or some scientific standard, to help us help the public understand what this is about. So with the banking problem, that's a problem too, because it turns out that it's okay, because if you're with a legitimate bank, you have insurance, So yes, it's going to be, going to take some time, annoyance, and so forth, but you're going to get your money back. There's an assurance that is there for the online user. However, if you do not know that, it does diminish the productivity and efficiency of the same system that you're investing in. That's the problem. So why does it matter? A lot of people ask me, oh, but some people, they don't really need it because they're just not as, whatever. The problem that I say is the effect of being offline is digital destitution, right? And that is a dynamic social institutional process of alienation and deprivation from the productive functions of society based on technology, right? I can tell you that almost half of the people that I mentioned are faced with that situation. I can't tell you their returns are an investment, that's a different conversation, but I can tell you for sure they don't have the mechanism to connect, right? Those are bottlenecks of potential consumers but ill-informed, it diminishes the potential efficiency and productivity and profit that we have, that we love the system for. Education is necessary and key. And right now, there's a lot of discussion, but the content of the conversation is problematic.
Yeah. I also want to just highlight the difference between trust and trustworthiness. So a year ago, we might have had more trust in our ability, before the Pan America study and before we had these leaks, there might have been a greater trust in internet systems and speaking freely. But that doesn't mean that the system was more trustworthy. We just didn't have information about what was happening.
Awareness.
A year later, there's less trust. There have been some reforms. Maybe the system is more trustworthy. More companies are adopting encryption, right? So there's sort of this interesting interplay between both of those things. And I think we definitely want to increase trust, but we also want to be increasing a reason to trust, right? The security and the sort of ability to predict what's going to be happening with your data, to be able to anticipate, the level to which you feel comfortable sharing and that's going to be out in the world.
Right, awareness of what you can and can't control.
Right.
I'm sort of curious whether any of us any longer believe in a subject that you introduced, which is anonymity, whether you really can be anonymous, particularly online, since we're talking about cyber surveillance. Do you think that's gone?
It's absolutely not gone.
Really?
It's technically very, very, very difficult. It's beyond the reach of all but the very most technically sophisticated. Legally, it's also not gone. There are ways of maintaining one's anonymity in a legal sense, even if in a technical sense your anonymity may be gone. So I think, not to be too confrontational, but I think to say anonymity is dead is defeatist. And if I woke up every morning and thought anonymity is dead, there'd be no reason for me to come into EFF and do my job. So I have to believe that anonymity is still possible, even anonymity online, in order to get up in the morning. Am I anonymous online? Of course not.
No.
I think there are also many levels of anonymity, right? There's, logging in using a pseudonym. Yes, for sure, if someone worked hard enough, they could probably trace your identity back to you if you're not also using technical tools. I mean, there's encryption, which is not necessarily going to make you anonymous to the universe, but will protect some of your information. So there's many, many layers to it. And if you use all of them, then I agree.
I'll use a concrete example. Let's say that I, using my AT&T Uverse subscription under my own name, go on Yelp, and my registration on Yelp is, let's say it uses a name that is not mine, but is connected to an email address that is mine. And I leave a negative review for Amy's Baking Company, the nightmare company in Phoenix that we all heard of last summer. I need to feel confident in order to leave that negative review that Amy and her crazy husband Sammy won't be knocking on my door spewing profanity at me in order to leave that review. I do have that confidence, even though it would be perfectly technically possible to trace that comment directly to me. I can still leave it knowing that there are legal protections so that Q549 will not be traced back by Amy to Nate Cardozo. It might be traced back by the FBI if I threaten her life, which I'm not going to do. But if I just say that her cookies suck, I can say that anonymously, even with taking no technical tools at all. So that's what I mean by anonymity is not dead.
Don't you think we should take some questions? We can't see you out there.
We can't see anybody.
But we want some questions from the audience as well. How much time do we have?
About 15 minutes.
Okay.
So that's a great idea.
Have we provoked any of you? I hope so. Only we still can't see you very well.
I'll give one quick anecdote while we're waiting for questions. Professor Glancy mentioned the CALIA switches that are embedded in communications hardware these days. I'll just let you I'll give you this little piece of information and let you give a thought exercise, because I don't think you should actually test this, but I'll assure you that it's true. Cisco, in its telecommunications switches, has an SSH account that the username and password are Kalia, all caps, 01 by default. Thought exercise, how many telecommunications providers change that default password?
Given the number of Cisco routers that have been hacked with the default password of Cisco, not many.
I'm also happy to make a comment if we, did you want to?
I did.
I mean, I'm happy to,
As I say, we
Talk
can't
to-
quite see you, so
Well, you have two people
do
that
we have questions coming in? Okay, I can hold that.
You can take first
Please.
turn and I'll follow you.
Okay. So I just actually wanted to complement what you were saying about. Oh, I am not accustomed to ask questions.
That's okay.
Only I wanted to complement what you were saying. I understand that there is so many issues of social privacy expectations, and many of them are due to misinterpretation of the law, and most of them is Fourth and Fifth Amendment. So maybe it will be good to have maybe that kind of proposals that you probably can make to Congress is Fourth and Fifth Amendment to be in some way implemented or like make it more clear, because it's so broad also. And also something else I was thinking is about FTC, Federal Trade Commission. In some way they were working with a lot of settlements with companies that were violating privacy issues. So I guess that can be also something to work out, FTC, and try to make work in the educational side, because I think it's powerful, as the lady was saying, if you educate and work with these companies in a way that can go, that can be spread, it's all about privacy and how companies can protect their consumers, and putting some tools that will help, I guess, to this issue. And also, as you said, privacy education in every single university maybe also can try to have this type of concentration. So I guess a powerful tool in developing countries, for example, is always the education and stand up. So I guess that's the only way that I see that social expectations will be covered about privacy. And then it's just a general ideas. Somebody said that the internet is a natural and intangible act that people will not truly appreciate it until they lose it. So people must not giving up or trust their rights to anybody, including government, until they truly understand the value of them and for your future generations. So I think so is somebody that say that, and I just kind of want to remember that maybe the way to go is just try to change the law in the Fourth and Fifth Amendment and going to the educational level, no? That's all.
Thanks.
Thanks.
I don't know, maybe you have something else to say.
What was the specific question? We didn't get your specific question.
No, I actually was adding something.
Oh,
that
yeah.
you were
Yeah. Great. Mike?
Well, I want to give other people the opportunity to ask questions. I don't want to hog the mic. Is there somebody with a question?
I just wanted to ask the question about the distinction between privacy expectations between small town Americans, that being the environment that I know, and big city Americans. I mean, if I were to make a comment in a small town about Amy's Bakery, I would have no expectation of privacy that it would not get back to Amy. Whereas if I told my friends in a big city about Amy's Bakery, I would have that expectation of privacy. And I'm sort of curious as to how that distinction of expectations of privacy affects our debate.
So I can answer this from the lawyer's perspective. The expectation of privacy is that we deal with in terms of the law is not the expectation of privacy as to whether or not it's going to get back to Amy, but whether Amy can use the power of the state to make that link happen. So I think that the expectation would be the same in big city versus small city. In terms of social norms, I don't know, Blanca.
Yeah, I think it varies, right? And I think that you point out that I was talking to a European colleague, and he's like, well, I don't know, you Americans, you care, like, we don't care. So we already know, our neighbors can see everything. Who cares? Get over it, And I said, yeah, but you know your neighbors.
Right.
You know who they are and what they might do with that information. And I think it is about just awareness. That's going back to the education. I think for companies who are seeking this value of being more aware, and, I think all of us are having to do that homework, right? What can you expect? And we do need updated educational mechanisms to understand what this structure is. It's actually urgent yesterday, many years ago, because it's evolving. But there are some constants, right? And those are the things that we can talk about. And so whereas before, you could do whatever, and it could be contained within the social network of information and legitimated or not by who knows what and what we think about you or not. Now there's an imprint of the information that's online, right? And sometimes you contribute to it, right? I'm amongst computer scientists all the time, and myself have seen proof of it with the people who are the most paranoid and most technically capable, and they show me right there how they can clean the whole system, and sure enough, they open up the engine, I guess, or they uplift the hood, and you see what's occurring. And in one search, when he went to the New York Times, there was like 25 people we counted, 25 third parties that collected his information, right? I was looking for Birkenstocks because I hurt my toe to come to this talk. And I just looked it up, and now I'm anywhere. It doesn't matter if I'm Facebook, it doesn't matter what platform I'm in. That's the point. I think people have this expectation, if I'm on Facebook and I have these settings, then nobody's gonna see it. No, that's not how it works, It's in the internet, means the network. It's where the information and bits of information, 0 ones, transmit to each other, right? So, there is a disruption. You could see it in the family, because there's the people who have certain beliefs about what is private or not. I just saw a video of this woman in Brazil who is hitting her daughter and shaming her on YouTube because she posted a picture of her not naked, but less modest online. So there's different ways that people are regulating, and some could be very problematic. It just, society reveals itself online. It is all of that we are, and the point is that we can begin to have a conversation more about how we're going to manage those effects. So what does happen when everybody can see you, and you didn't have a pause, and now everybody passed it on? How are we as a society going to respond to that? Some people I heard are hopeful that and everybody talks about the government and so forth, but the majority of the people that are going to care are the consumers, right? That's why this matters. This is a public. It's a game, right? It's policy, and so right now, the government's losing, and so. But the point is, if you want informed policy, then we have to kind of put those games away and recognize that there is disruption, there is preventable harm, and the worst kind of harm is based on ignorance, not knowing what is, right? So we should prepare the people who are supposed to be guiding us and making decisions about what is just the internet, its infrastructure. Barry Waldman calls it the internet is the brain, and the World Wide Web is the mind. I mean, this is where metaphors and language is going to matter in the court, right? With that smartphone. So what happened is that this person, you're the lawyer, but as I understand it, is if you come and arrest me and my phone is on, and you open it, and it has all my information, right? Like I can track how long I've been where, and who I talked to, how long I've talked to them, and so forth, maybe even recordings of our conversations, and so forth.
And
if I had
Riley had pictures of his stash house on his phone.
Right. You know what I mean? Like,
Clever.
that's not very clever. And so that's a form of ignorance because you're self-incriminating. And that's the problem, that within the context of social structure of inequality and differences, of ideologies of differences, there's a lot of harm to be done amongst ourselves. You know, and like this woman said to me, I heard they were like, oh, I heard in this conversation, oh yeah, did you see it on Facebook? So and so is their friends, and did you know that they went on vacation the other day? Oh yeah, they're really great. She's like, you know, if everybody puts their business online, I'm so willing to lure because that's, you know, because they're putting it out there. I'm a willing participant. You know, so the important thing I think is for us to know that this is an open network. Which the world has opened up bigger than our homes. How do we feel about that? And what do you want to contribute? Does it matter? I think for the young people, it's about inferences. For some people, it's about censoring. It's just, it's a disorder. There's disruption because there's a crisis of understanding. And the world is changing. There's more people. More people can see things. Things don't just disappear. They can be multiplied. And so the question is, for scholars, I think, is what are the social norms, you know? And I think ought to be careful about how we frame it. So I was just gonna say about the phone, right? They found it. So the question is it like going into your home or is it like getting into your wallet? You know?
Or is it like going into a cigarette pack to see if you've put something
It's
in?
how you frame it is going to determine the cost. That's why it really matters what language we use. And even be cautious about how we think about and do we want to reinforce that? For instance, I thought it was very interesting the language that was used about the revelations of Snowden. I was like, revelations, is that because they came from the inside out? Because these things were known. It's just, it wasn't in the public forum. And that's where the game begins, right? So, but for educational purposes, it's about...
Just timekeeping, we've got like 1 minute left.
Yeah, so I'm just a promoter of education so that we can get into a serious dialogue about what choices we have available or what we choose. So there's what is and what we can imagine. And so that's both a great opportunity and the challenge.
And it gives people power.
Yes, and also recognize what's our agency around this.
Emily, you have some final words? Or we have another question.
Yeah.
Once again, it's hard to see you.
Yeah, based on your expertise in the legal field, what do you recommend in terms of understanding what type of information, like for background checks, are available that I'm not aware of? For instance, I had my luggage stolen with my checkbook and even passport. And so I immediately bought this LifeLock stolen ID thing, right? And it seemed like things were being taken care of. I changed my account numbers and things like that. But later on, there was where I wanted to renew my house and auto insurance. And so I was talking to an agent, and they did, you know, kind of a background. I had to give them my social security number and my driver's license number. And he gets back and says, "John, I can't believe you're driving without a driver's license, and your sons were in accidents, you know?" And wow, I'm the last one to know, okay? And so I really got on the case of LifeLock. I said, look, this is an artifact of stolen ID, or someone is corrupting my background, and I'm not even aware of it, and I'm paying for services, okay? So that's the other, even if you do have good intentions and you pay for services, you may not get what you're paying for.
Yeah.
Do you have some final
Oh, that's okay. I think
I mean, having your identity stolen, I mean, privacy is about maintaining control over your identity, and identity theft is about the worst thing that can happen to anyone. But for you, it was also further trust that an online business could help you. Personally, if I were in your shoes, I would go to the California Attorney General's office, which has a very good enforcement division that deals with these issues very effectively. And you wouldn't have to pay someone to do it for you.
Yeah. But can we,
anonymously check our background or.
Yes. You can check your credit
Not
rating and your
anonymously.
credit reports, sure.
Yeah.
You can, and it's free,
Yeah,
once a
credit
year.
reports, but I'm thinking there's these other artifacts that can create a lot of harm. I mean, for example, if I had gotten in an accident or something like that, okay?
Yeah.
Apparently,
You would
know,
have gone to jail.
Yeah, I was driving without a license, and that was not true. So I should be the first one informed, if, you know, why it was, and that was the other thing, is I had to arm wrestle this for over 4 weeks with the Department of Motor Vehicles, okay?
They're very tough.
You know, there was a problem, it was a glitch, you know, in their database.
So one of the differences, one of the main differences between American privacy law and European privacy law is that in Europe Europeans have a right to know what businesses know about them. We don't have that same right in the United States.
I think you're right.
So that's,
It's all about harm reduction.
Yep. All right.
Okay, we're going to wrap this panel, and we're going to have a break of about
Yes.
12 minutes and reconvene at 3 p.m. Panelists, if you could just slip back here, they're going to turn your mics off because you're going to be on the next panel.
All right.
Thank you.